Hi, this is Lee, and on this video, I wanted to discuss drafting a bill title in the California Legislature. Pursuant to Article 4, Section 9 of our California Constitution, there's a requirement for each bill to have a title. This provision of the Constitution says a statute shall embrace but one subject, which shall be expressed in its title. If a statute embraces a subject not expressed in its title, only the part not expressed is void, and the statute may not be amended by reference to its title. So the title is used to provide a description of the bill. Now, because of this constitutional provision in Article 4, a bill's title must be legally sufficient. So a bill drafter usually prepares the title after the body of the bill has been drafted. As each bill is required to contain one broad subject matter, the subject needs to be expressed in the title of the bill. And pursuant to the California Constitution, an enacted bill is void if the subject is not expressed in the title. As a general rule, the title needs to be broad enough to be germane to the same general subject. As a result, the title must identify generally the subject matter of the bill. The purpose of the bill is that by reading the bill's title, a person should be able to determine what the bill actually deals with. In addition, the legal purpose of the constitutional title requirement is to prevent the concealment of the true nature of the provisions of a bill from the legislature and the public. As a result, the title of the bill serves as a means of identifying the subject of the bill. And so it's important that the title should describe what a bill is about rather than what the bill does or how the bill accomplishes its true purpose. Keep in mind that the requirement in Article 4, Section 9 is mandatory, and that a bill that fails to comply with this requirement is void. In order to comply with this requirement, the title basically needs to give notice about the subject matter of the bill. Now, as a general rule in California, a bill begins with the phrase "an act relating to." This language expresses the subject of the bill in its title, such as relating to local government finance or relating to taxation. The practice in California and many other states is to include the references to code sections and whether the bill adds, amends, or repeals these code sections. The title of a bill should designate the subject of the bill in general terms, but not in detail. So the title needs to be broader than the subject matter that's dealt with. It should not be narrower. This is why a bill reader might see in the title relating to personal income taxation, rather than a narrow title such as an act relating to personal exemptions under the income tax law for persons 65 years of age or older. If a title were to include a detailed description of the subject matter of the bill, then the title would have to express every detail in the bill. Otherwise, any detail of the bill that was not included in the title might be held invalid by a court. On the other hand, a title so broad may not comply with the constitutional requirement in Section 9 of Article 4. For example, the Oregon Supreme Court ruled that the title relating to the activities regulated by state government had failed to identify a single subject, as it was so broad that it did little more than define the universe with respect to which the legislature is empowered to act. So generally, bill drafters in our state prepare the bill title after the other parts of the bill have been drafted, so that when they draft the title should fit the bill, rather than the bill being drafted to fit the actual title.